So I'm going to let me welcome you all to the final of the 2022 FDI Moot All Africa Regional. We have before us Team Sebutinde representing the claimant and Team Elaraby representing the respondent, and a tribunal consisting of Mr. Hamid Abdulkareem, Diego Mejía-Lemos, and Mr. Stephen Finizio presiding. And I will turn the microphone over to our presiding arbitrator now.
Well, thank you and welcome and congratulations to being in the finals. Before we get started formally with the hearing, I thought we would take a minute before we go into full role-playing mode to introduce the tribunal. And why don't I ask Diego to start by briefly introducing yourself?
Well, thank you, Stephen, and it's a pleasure to be on the panel today. So my name is Diego Mejía-Lemos. I have held positions both in practice and academia, and currently I hold a distinguished research associate professorship at Xi'an University, and I have been very actively involved in this more than other motor competitions. And I guess I'll stop there. Thank you.
Thank you, Diego. Hamid, do you want to introduce yourself?
Thanks very much, Stephen. Hello, everyone. My name is Hamid Abdulkareem. I'm counsel at Three Crowns in London. Before Three Crowns, I used to practice out of Nigeria. I was a partner at Abdulkareem in Lagos. I was an avid mooter as a student and a younger practitioner. So, very happy to see you all and wish you all the best.
Thank you, Hamid. I am Stephen Finizio. I'm a partner at Wilmer Hale based in London. I'm not an English lawyer. I'm an American lawyer, if that matters to anything. I also sit as an arbitrator and I teach at SOAS, and I have never participated in the FDI moot as counsel, but I have had the pleasure of having done the All Africa Finals before. So I'm looking forward to seeing what you can do and for you to live up to the past great performances. No pressure. Unless you have any questions at this point, why don't we begin the arbitration? And as part of that, after we start, I'm going to ask both sides to tell us whether or not you've reached an agreement on the sequence of arguments. But I will start by saying we have the matter before us of Sutton versus Rekia, and we're operating under the ICSID arbitration rules. And if we can hear from Claimant's counsel in the first instance as to whether there's an agreement on the sequence and timing of arguments.
Mr. President, members of the tribunal, I can confirm that we have agreed as to the order of arguments. We will begin with the procedural phase, where the first speaker will be respondent one for Team Elaraby, making arguments for 19 minutes, reserving 1 minute for rebuttal, taking a total of 20 minutes. The second speaker will be from Team Sebutinde, that is I. I will take 18 minutes for arguments, reserving 1 minute for rebuttal, a total of 19 minutes. Then we will proceed to rebuttals and rebuttals, that is within the procedural phase. Thereafter, we will begin the merits phase, where the third speaker will be from Team Sebutinde, that is Claimant 2, where she will submit to this tribunal for 20 minutes, reserving 1 minute for rebuttal, taking a total of 21 minutes. The fourth speaker will be respondent 2 from Team Elaraby, taking a total of 19 minutes for arguments, reserving 1 minute for rebuttals, taking a total of 20 minutes.
Okay. Thank you for that. Can respondent confirm that is the agreement?
Yes, we confirm that that's the agreement. Both counsel for respondent will be speaking for 19 minutes each, reserving 1 minute for rebuttals and rebuttals.
Okay. Thank you very much. One thing I want to highlight is that you need to be responsible for tracking time. We will try to track as well, but don't rely on us to tell you if you're running long, and you might get a surprised request to wrap up if you have run long, even if we haven't been warning you ahead of time. And then the other thing I would warn you of is that we're going to try as much as possible to stick to those times. So even if the tribunal asks you questions, we're going to try to keep you to your time limits, as, except in perhaps exceptional circumstances. So unless my colleagues have any questions or comments, or any of the council have any questions or comments, I would propose that we begin with the procedural arguments, and we are hearing first from respondent on that issue, right? Any questions from anyone?
None from
Right.
me.
None. Please go ahead.
Right. So respondents first, council.
Good day, members of the tribunal. Once again, my name is Oluwasemilore Olowokure, counsel for respondent in the present proceedings. Members of the tribunal, the present dispute has already been settled. Donald and Daisy, majority shareholders of Claimant, previously brought this claim and lost. In a feeble attempt to revive their lost claim, claimants have essentially dressed the same claim in different garments. They have also failed to exhaust local remedies, completely ignoring this procedural requirement. As such, we will be addressing two procedural objections in today's proceedings. Firstly, this tribunal lacks jurisdiction because a previous tribunal has already decided this dispute, and this has res judicata effects. Secondly, this tribunal lacks jurisdiction because claimants have failed to exhaust local remedies. On the first issue of res judicata, in the previous case of Donald and Daisy versus the Republic of Rekia, as earlier stated, Donald and Daisy, majority shareholders of Claimant, brought a dispute that their investments in Rekia had been destroyed. They lost on all counts. This previous award has res judicata effects on this case, and in order to determine this, we must determine that the parties, the objects, and the grounds of both disputes are the same. This is in line with the test by Judge Anzilotti in his dissenting opinion in the Chorzo factory case. Members of the tribunal, we submit that in the present dispute, all three requirements have been met. This tripartite test has been endorsed in recent investment law cases, such as Gavazi versus Romania and Ampal American versus Egypt. Members of the tribunal on the first requirement of same parties. Parties are considered to be identical when they share privity of interest. And this is where two parties essentially have their interests rooted in the same investment. If I may please direct the attention of the tribunal to page 23 of the record. This would be page 26 if it's the PDF version. This contains our response to Claimant's request for arbitration. And here we see the corporate structure of Claimant. Donald and Daisy own 75% of certain holdings, which in turn owns 100% of certain investments. Thus, essentially, Donald and Daisy own 75% of certain investments. There should be no doubt that they share privity of interest with certain holdings. The tribunal in Ampal American versus Egypt held that where a treaty allows a shareholder to pursue a direct claim for losses to an investment that he holds indirectly through the enterprise, then the consequence is that the shareholder is treated as privy to the investment for the purpose of res judicata. We are faced with the same situation here, members of the tribunal. Donald and Daisy—
Counsel, does that particular ruling on that definition of privity, is it applicable to every kind of investment? And in particular, taking into account the fact that in the previous proceedings, what was claimed was a damage in the form of loss of value of shares, whereas here we are speaking of damage that has been directly inflicted upon physical assets.
Yes, Mr. Arbitrator, this rule is applicable in the present case In the case of Ampel American, the majority shareholders were also pleading for damages for the diminution of the value of their share. And this was still they were still held to have privity because they relied on a provision that was basically on behalf of the company. Essentially, they were bringing a claim on behalf of the company as provided for by the BIT.
If I can also ask a question there, in that case, was that the second claim or was that the first claim? In the case you're relying on.
In that case, the first claim was a claim for the damages for the diminution of the value of their share, and the second case was the tribunal's direct claim. Specifically, was a claim for FET. So similarly, in this case, the previous shareholders are claimed for their reflective losses, and in this case, we have a claim for direct losses to the company. Essentially, the test in Ampel American is that where the reliance is on the BIT allows shareholders to bring a claim on behalf of the company, then it will be deemed that they are privity to the company's interest.
Well, let's explore that then. You say when a shareholder can bring a claim on behalf of the company. Is that what happened here? And I'm troubled a little bit, and maybe this is a different issue, by the fact that the actions of a 75% shareholder in this case would potentially prevent other shareholders from having their value in their investment protected. So let's take those two questions for you, really. One is, in the first case here, were those shareholders acting on behalf of the company, or are they acting on behalf of themselves and the value of their shareholding? And second, is the principle right that a majority shareholder's actions can affect the value vis-a-vis other shareholders as well?
And I wonder generally, we have proceeded on the assumption that this interpretation of identity of parties as in terms of there being privity is applicable, but I wonder if that holds true in terms of general international law. Initially, you referred to the tripartite test and to the separate opinion of Judge Ancelotti in the course of factory decision, but you haven't provided any general international law authorities on your reading of the requirement of identity of parties, and I wonder if you have any that you would like the tribunal to take into account.
Thank you, Mr. Arbitrator. On the first question of whether the claim was on behalf of the company, we submit that it was in fact on behalf of the company. If I may please direct the attention of the tribunal to page 33 of the record, paragraph 10. If the tribunal is with me, this contains the previous award of Donald and Daisy versus Rekia. The second sentence reads, they are claiming for so-called reflective shareholder losses on behalf of an enterprise that they own or control directly or indirectly, which was subjected to various attacks and lootings from 2014 onwards. Thus, the previous tribunal recognized that the claim was on behalf of the company. On the second question of what happens basically to the minority shareholders, Mr. Arbitrator, the BIT provides that minority shareholders are allowed to only bring a claim for their direct losses. Thus, the BIT provides a separate cause of action for minority shareholders under the BIT, whereas majority shareholders can fully represent the interest of
Yeah, I guess that doesn't really answer my question, though, because if the company itself brings a claim and recovers value, those minority shareholders don't need to bring a claim, but they get the benefit of the value recovered by the company. And so it's the question of whether they can bring a separate claim doesn't fully answer the question of the value for the company being recovered by the company.
Mr. Arbitrator, the BIT recognizes that the BIT assumes that the majority shareholders have their interests aligned with that of the company. This is why it does not require the majority shareholders to show any proof of conference with the company or conference with the directors of the company. It automatically assumes that the majority shareholders have their interests aligned with the company, and thus they are able to bring a claim on behalf of the company.
I guess that's assuming your understanding of what that passage of the previous award means, that they were actually bringing the claim on behalf of the company. I'm not sure that that sentence means that. I don't want to get hung up on this, but that sentence could be read to mean that the loss was suffered by the company, and the claim is certainly in that arbitration was brought by the shareholders and not by the shareholders on behalf of the company. But why don't we keep moving?
All right, Mr. Arbitrator, just to clarify on this point, the provision in the facts of the case is based on the express wordings of the BIT that majority shareholders can bring claims on behalf of the enterprise, and there is no need for any conference or proof that the company is, the interests are clearly aligned. On the third question of the source of res judicata, although it's not explicitly recognized by the ICSID Convention, it is recognized under Article 53, sub 1 of the ICSID Convention, which states that decisions are final and binding between the parties. And on this basis, res judicata is applicable in investment law cases. Moving on to the second requirement of same objects, the object of a claim refers to the relief sought. And tribunals have recognized that where an application of the res judicata principle could lead to artificial claim splitting to avoid the application of the res judicata effect of a prior award, then this would not be in line with the objects of res judicata principle. Thus, the facts in issue are considered. And the tribunal in the Machado case stated that whether the claim is a new one does not depend on whether the items included be the same in both cases, but that the test is whether both claims are founded on the same injury. Members of the tribunal, both claims originate from the damages suffered by certain investments during the Rekian Civil War. Donald and Daisy, in the previous dispute, alleged that the acts and omissions of Rekia towards certain cannabis plants had a causal impact on their shares. Thus, their claim for losses in the previous claim was directly on the basis of the destruction of certain cannabis plants. Thus, we submit that the objects of both claims are the same. On the third requirement of same grounds, both claims are based on the same legal ground, which is the Athabaskan Rekian BIT. And this is so despite the fact that there are two language versions of the BIT. This requirement refers to the legal standards relied upon by claimant in support of the relief sought. And the tribunal in Stati versus Kazakhstan, in line with the provision of Article 33, paragraph 3 of the VCLT, stated that where there are multiple language versions of a treaty, it should be considered one single treaty with a single set of terms. Thus, in the present case, both language versions must be considered to refer to the same treaty, providing the same legal ground for claims. And in any case, if the versions are considered to be different, then the Rekian version will take precedent due to the fact that the treaty the subsequent practice and agreement of the parties shows that the interpretation of the Rekian version of the treaty is most preferred by the parties, in line with Article 31 of the VCLT. Members of the tribunal, during negotiations, Rekian delegates expressed that it was essential that the treaty allows for reflective shareholder losses.
Council, could you please elaborate briefly on how Article 31st of the VCLT allows you to substantiate the proposition you just made concerning the place of the subsequent parties' practice or agreements in terms of defining which language's version is to be preferred for the purposes of this element of identity of legal cause of action.
Mr. Arbitrator, Article 31 provides that in interpreting treaties, recourse should be made to any agreement made in connection with the conclusion of the treaty. And it also provides that we should make recourse to any subsequent practice or agreement which establishes the parties' agreement on interpretation. Thus, based on this provision, we see from page 52 of the facts of the case, the second paragraph, which contains the communique by Inga Magnuso, the Minister of Foreign Affairs in Athabasca. We see from that provision that during negotiations, it was expressed that the inclusion of reflective shareholder losses was essential. And where the discrepancy in the provisions in the BIT was later noticed, this was brought to the attention of the Athabascan representatives. And again, there was no—
But Council, is that not rather preparatory work instead of some form of subsequent practice or agreement in terms of BCLT Article 31st?
Mr. Arbitrator, the subsequent practice or agreement we refer to in this case is that after the conclusion of the treaty and where the discrepancy was noticed, the Rekian delegates informed Athabasca that there was a discrepancy, but this is the interpretation that we agreed to. That is the interpretation that allows for reflective shareholder losses. Thus, this subsequent practice shows that that was the interpretation that the parties agreed on. And the Athabascan representatives did not object to this interpretation subsequently. If that answers your question, Mr. Arbitrator, we thus submit that the legal grounds are the same, and I will now be proceeding to issue 2 on exhaustion of local remedies.
Very briefly, before you move on, I wonder to what extent, although we are speaking of the same treaty, the fact that in these proceedings, Claimant is relying on a different standard of treatment has an impact on your submission that the ground for action is identical. And I wonder this because even if we were to assume that the facts are the same, that the injury is allegedly the same, however, as assessed by reference to a legal standard of treatment, perhaps the assessment could differ from what would be the conclusion based on a different standard of treatment.
Mr. Arbitrator, I understand your concern. However, for the purpose of res judicata, in order to avoid the tendency of claim splitting, claims cannot be differentiated based solely on different theories of damage. And this was the holding of the tribunal in the case of Apotex versus USA. Thus, we submit that solely on the basis of different theories of damage, which is basically different provisions in the BIT, it cannot be said that the claims are different when both claims originate from the same injury. If this answers your concern, Mr. Arbitrator, I now proceed to issue 2 on exhaustion of local remedies. Mr. Arbitrator, the non-compliance with this clause by Claimant bars this tribunal from hearing this dispute because Claimant has completely failed to exhaust local remedies and there is no applicable defense. Article 12, paragraph 2 of the BIT provides that disputes shall not be referred to arbitration until this clause has been complied with. And Article 31, paragraph 1 of the VCLT states that treaties must be interpreted in line with the ordinary meaning of their words. Members of the tribunal, the ordinary meaning of the word shall in an agreement is an expression of a mandatory rule. And this means that the exhaustion of local remedies requirement in Article 12 is in fact obligatory. Also, members of the tribunal, the purpose of the exhaustion of local remedies clause is to allow a state a reasonable opportunity to address to address the issues within its local courts. Members of the tribunal, we submit that this objective has been thwarted by Claimant's disregard for the clause for the exhaustion of local remedies clause.
Can I quickly ask a question on this? Are we entitled to consider the outcome of the Donald and Daisy domestic litigation in assessing whether or not there was a available local remedy for Sutton?
Mr. Arbitrator, before I answer that question, I see my time is almost up. and request for an additional minute to answer your question and round up.
As I said, we're going to try to keep to the time limits, but we'll give you small additional time. So 1 minute extra is granted, and you can be quick on my question.
Mr. Arbitrator, we submit that firstly, the futility exception should not be even considered by this court, by this tribunal, because the exhaustion of local remedies rule is a lex specialis, and this is in line with the tribunal's tribunal Ikale versus Turkmenistan. However, if the tribunal will still consider the futility exception and consider the Donald and Daisy award, it will still show that remedies were in fact not futile, and we urge the tribunal to consider this fact that Donald and Daisy completed their claim in less than a year, in less than 12 months, which is sufficient time, members of the tribunal, for the 18-month requirement to have been satisfied. Thus, we submit that in any case, remedies in Rekia were not futile. Members of the tribunal, we humbly ask that you find that this tribunal lacks jurisdiction to hear this matter. If I can be of no further assistance, this concludes our pleadings on procedural objections.
Thank you. Any questions from my colleagues?
No.
Okay. So then we will hear from claimant's counsel.
If I may proceed. Mr. President, members of the tribunal, good morning, good afternoon, good evening from whichever part of the world you are. My name is Morara Lewis, and I'm joined by my co-counsel, Esther Nibuto, and together we act on behalf of the Claimant Certain Holdings Incorporation. I shall undertake in the next 18 minutes to submit to this tribunal on the procedural aspect of this dispute on jurisdiction. Lies are like cockroaches. Whenever you spot one, there might be more. With this backdrop in mind, we make the following submission. We make the following broad argument that this tribunal has jurisdiction. In order to prove this, we make two interrelated arguments. One, that this tribunal has jurisdiction in light of inapplicability of res judicata. Two, that this tribunal has jurisdiction in light of inapplicability of exhaustion of local remedies rule. To prove our first point on res judicata, we make three interrelated arguments. That is, that the parties are not the same either formally or in essence. Secondly, that the subject matter in relation to the prayers for relief being sought is different. Thirdly, that the cause of action in relation to the legal foundation is also different. On to our first issue, claimant submits that this tribunal has jurisdiction in light of inapplicability of res judicata. But perhaps before we move into the substance of what res judicata is, it is important that we make the following preliminary points. We agree with respondent in as far as res judicata is a principle of international law, and that the rationale behind it is that there has to be an end to litigation, and that a party should not be subject to dual litigation. However, we disagree with counsel for respondent with regards to characterization of the three conditions establishing res judicata. Members of the tribunal, Judge Anzelotti, in his dissent opinion in the case of Factory at Chozo, established three conditions, that is, same parties, same subject matter, and same cause of action. This has been reapplied by numerous tribunals, such as the tribunal in the case of CME Czech Republic BV versus the Czech Republic, a decision by the UNCITRAL Tribunal of 14th March 2003. Consequently, we will be making three interrelated arguments with regards to these three conditions. On to our first line of argument, claimant submits that the parties are not the same either formally or in essence. In response to counsel for respondent assertions, that is the Donald and Daisy, I would like to draw the tribunal's attention to page 68, as at paragraph 56. If members of the tribunal are with me, as at paragraph 56, the last line reads, in particular, Donald and Daisy hold 75% of the shares in certain holdings, of which 30% was owned by Donald and 45% was owned by Daisy. The reliance by respondent counsel on the principle of, with regards to the principle of privity of interest, they have forgotten to tell you one thing. That is, with regards to privity of interest, with regards to shareholdership, there has to be the aspect of ownership and control. It is evident, as at page 68, paragraph 56, Donald and Daisy do not have effective control over the present claimant. Therefore, the correct test should be...
Counsel, just to
Mr.
clarify what the sense of your submission on this issue is, the issue of the identity of parties. I wonder, are you relying on the same principle that that respondent has relied on, but you contest its applicability, or are you relying on some other principle? You said that formally and substantively, the parties are not the same. So formally, one will rely on the principle of separation of legal personality, right? I wonder, are you asking this tribunal to take into account this principle in addition to the principle of privity that is or is not applicable in the present circumstances? Could you clarify what is ultimately the legal basis of this part of your submission?
Very well, Mr. Arbitrator. It is our submission that regards formality that in the first case of Donald and Daisy, the case was launched by claimants who are individual shareholders. And in the present dispute, we have a corporate legal entity. Therefore, with regards to the form of the parties, they have separate legal entities. With regards to the second bit of your question, that is on the principle in relation to the aspect of privity of interest, we submit that in order for respondent to satisfactorily rely on that principle, they have to show two aspects, that is ownership and control. They have shown that indeed Donald and Daisy have ownership, they own 75% majority shares, but they have not in any way shown that they control the present claimant. Further, we make reliance, if I have answered your question, Mr. Arbitrator, we make reliance on the privity of identity of interest in relation to shareholdership. That is, there has to be 100% shareholdership in order for privity of interest to exist as between parties. We rely on the string of jurisprudence as was established in the case of Escosol SPA in Liquid Zone versus the Italian Republic, where the tribunal found that in order for privity of interest to exist between parties, there has to be 100% shareholdership. By contrast, Donald and Daisy only own 75% majority shareholdership. Therefore, in essence, Donald and Daisy are not in any way the same as the present claimant. Members of the tribunal, I now move on to the second issue, and the second limb of argument, and that is in relation to the subject matter with regards to the prayers for relief being sought. I draw the tribunal's attention to page 6 as at paragraph 5. If the tribunal is with me at page 6, paragraph 25, beg your pardon, where it is evident that the reason as to why the claimant filed this current dispute is because the claimant's assets were fundamentally impaired. This is due to the production plants at Freya and Odin suffering extensive damage from gunfire, arson, and explosion. Therefore, in that regard, claimant relied on compensation for physical damage with regards to claimant's investments. However, by contrast, and if the tribunal might move with me to page 32, as at paragraph 6, if members of the tribunal are with me, as at paragraph 6, it is evident that in the year of 2014, the severe uprising in Rekia led to several attacks on plants, causing severe damage to the facilities, which forced Saturn to stop all production until 2017. These caused a decrease in the value of its shares. Therefore, members of the tribunal, it is evident as at paragraph 6 of page 32 and page 6, paragraph 25, that the prayers for relief being sought in this present dispute is different from the prayers for relief that were being sought in the previous dispute. Compensation in this dispute is in relation to is in relation to the physical damage that was caused on the investments at Odin and Freya, whereas compensation in the first dispute of Donald and Daisy was with regards to individual loss of their shares. I will move on to the third limb of argument, that is in relation to the cause of action, where we rely in the case of Karatub International Oil Company, LLP, and others versus the Republic of Kazakhstan, where the tribunal found that in order for the cause of action to be the same, there has to be reliance on the same legal rights and reliance on the same legal foundation. Members of the tribunal, I will draw your attention to page 7 as a paragraph.
Council,
26.
so why should we take into account this particular understanding of identity of cause of action? And what is your position regarding respondents' submission that identity of cause of action is satisfied merely by the fact that the claims being advanced are based on the same legal instrument, in this case, the same BIT?
Mr. Arbitrator, to answer your question and in response to counsel for respondent, she alluded to the fact that what is allegedly being done here is claim splitting. However, it is our submission that claim splitting would amount to the general principle of international law termed as lispendence, whereas in the present dispute, we're dealing with res judicata. Therefore, the question is not whether we could have raised these issues in the past dispute, but rather whether we have based our cause of action on the same legal rights as Donald and Daisy did. So therefore, these are two different questions pertaining to lispendence and res judicata. In the particular case, we are faced with res judicata.
Well, if we don't agree with you that there's a difference in the identity between the shareholders and the company, it would follow essentially, wouldn't it, that the same entity has chosen to assert particular claims for relief in the first matter, and in this matter, it has chosen entirely different basis for claiming its relief, but ultimately to serve the same purpose. So it doesn't follow, I don't think, that the distinction between lispendence or res judicata, means that in essence we do not have a potential abusive situation here, does it?
Very well, Mr. Arbitrator. We rely on the decision of Cavazi versus Romania, a decision on jurisdiction, admissibility, and liability. With respect to the issues that were raised in that case of double recovery, the tribunal found that double recovery would not have taken place because the parties in that dispute were separate legal entities. And having made our submission that in this case we are separate legal entities, therefore the compensation that was relied in the first case of Donald and Daisy would not in any way have ultimately led to the present claimant being compensated. Okay, just put you back on track. So we're not concerned about double recovery. We can take care of that. It's merely a matter of principle. Is it right? Assuming we took the position that the claimant is the same. This claimant essentially in one set of proceedings made certain arguments on the basis of certain provisions of the BIT. In another set of proceedings, it's chosen to assert different standards under the BIT. The fact that it has chosen to assert different standards under the BITs, can that provide a basis for arguing that essentially the claims are different? That will be the essence of contracts of claim splitting, wouldn't it? Which is what respondent argues that claimant is doing here. Mr. Arbitrator, to answer your question, with regards to claim splitting, we base our reliance, the cause of action leading to the issues that are before this tribunal are totally different. I will direct this tribunal to.
But maybe, counsel, before you direct us to another part of the record. So it seems that you are asking us to decide whether the cause of action is or is not the same, based on whether the same legal right is involved or not, if I understood correctly your standard. But how are we going to decide if we're dealing or not with the same right? I had asked the other party whether the issue of relying on different standards of treatment under the same BIT would imply that there is not the same legal cause of action. And I wonder, in terms of your test, is the difference of a standard of treatment something that will impact the standard that you're asking us to apply, which is, are we dealing with a different right or not?
Mr. Arbitrator, to answer your question, indeed, we are dealing with different rights because in the first case of Donald and Daisy, the rights that were relied upon in the first case were the rights pertaining to the Arthur Baskerville BIT of expropriation. By contrast, in the present dispute, we are relying on the rights that were obviously the respondent has failed in its obligation to provide full protection and security. Consequently, with regards to cause of action, reliance on different rights would mean that cause of action is not considered the same. Also, in relation to the cause of action, it is our submission that the legal foundation is different. I will guide the tribunal to page 79, that is as Article 13(2)(b)(2) of the Athabasca-Rekia BIT. And if the tribunal is with me, Article 13(2)(b)(2), that is the English version of the Athabasca-Rekia BIT, provides that the claimant is the enterprise. And if the tribunal moves with me to page 87, as Article 13(2)(b)(2), the claimant is it. Therefore, it is our position that in as much as the Rekian version provides that the claimant is it, that this statement is ambiguous, and that therefore this tribunal should resort to a matter of interpretation. We rely on the Vienna Convention on Law of Treaties as at Article 33. Members of the tribunal, the Vienna Convention on Law of Treaties as at Article 33 makes provision for interpretation of a treaty that has been authenticated in more than one language. Particularly, paragraph 4 states that subject to the first paragraph, where an authentic text conveys a difference in meaning of which Article 31 and Article 32 do not remove, then the text which best reconciles a treaty with regards to its object and purpose should be adopted. In this light, I will draw the tribunal's attention to page 72 of the statement of, that is page 72, where it is evident that the object and purpose of the Athabasca-Rekia BIT is to create a stable framework with regards to investment. It is therefore a position that the narrow interpretation of the English version of the Athabasca-Rekia BIT with regards to providing that the claimant should be the enterprise would in essence provide a stable framework with regards to investment. This was, as in the case of Kilic versus Turkmenistan, a decision on Article 7.2 of the Turkey-Turkmenistan BIT. Members of the tribunal, I now move on to our second line of argument, that is in relation to exhaustion of local remedies, where claimant submits that this tribunal has jurisdiction in light of inapplicability of exhaustion of local remedies. In response to counsel for respondent assertion that Article 12 of the Athabasca-Rekia BIT has a mandatory requirement, it is our submission that if we rely on the Vienna Convention on Law of Treaties as at Article 31, which makes provision for the general rules of interpretation, that good faith should be the underlying principle and that ordinary meaning should be given to words with regards to a treaty's purpose and object. Members of the tribunal, as at page 72, the purpose and object of the Athabasca-Rekia BIT is offering a favorable and equitable condition for greater investments by investor. Therefore, it is our submission that Article 12 of the Athabasca-Rekia BIT will not in any way hold as a mandatory condition, as it cannot subdue the purpose and object of the Athabasca-Rekia BIT.
But Counsel, I have a concern here with your interpretation. When you're asking us to rely on the preamble, you're asking us to rely on a material that is not part of the operative clauses of the treaty, that is therefore not binding. Whereas respondent has pointed out to the use in the respective article of the auxiliary verb shall, which is in ordinary language understood to mean obligation. How do you counter this? And why should we give prevalence to the preamble in order to overcome what seems to be a very clear indication that it is exhaustion of local remedies is being provided for as a compulsory condition for arbitral jurisdiction?
Mr. President, Mr. Arbitrator, to answer your question, we make our reliance on the Vienna Convention on Law of Treaties as at Article 31, which states that in treaty interpretation, good faith is the underlying principle, and that the purpose of a treaty and in its context should be taken into consideration.
But Counsel, you're leaving aside the most important part possibly, which is the text of the treaty.
The text of the treaty.
So how do you reconcile the obligation to rely on the text of the treaty on one hand, and on the other hand, these other elements that are in a way less binding within the scheme of VCLT Article 31st? I mean, if you could address this briefly so we can move on in the interest of time.
Yeah, and let me make 2 points. You're past your 18 minutes, but we'll give you an extra minute. And I would like sort of a alternative version of the question before you. What does Article 12 mean then under your approach?
Mr. President, thank you for the time extension. I also note that I am way past 19 minutes. To answer your question, Mr. Arbitrator, with regards to consideration of the text, that is, which in relation to the text shall, it is our position, and we base our reliance on Kilich versus Turkmenistan, a decision on Article 7.2 of the Turkey-Turkmenistan BIT, where the tribunal in this case considered that exhaustion of local remedies where there has been resort to sort of consultations and negotiations as between parties, then that in itself ousts the mandatory requirement. It is evident as at page 92, paragraph 21, that there was resort to consultations and negotiations between both parties.
Just so I understand and we can wrap this up, is your argument that there simply isn't a requirement for exhaustion of local remedies, which is what I'm hearing you say, but I don't suspect you mean, but maybe you do? Or is your argument that there are exceptions depending on the facts that allow that condition to be excused?
I'm sorry if I wasn't clear. Our position is that there are exceptions to these mandatory provision. This has been found by previous tribunals, such as the tribunal in the case of Ambiento, Official, and others, versus Argentina. But the tribunal found that.
Could you quickly, rather than telling us what that tribunal found, can you quickly tell us? No.
Indeed.
What exceptions do you say apply here?
The exceptions are that where there has been sufficient minimum amount of consultation that has been conducted, and where there is amicable consultations in order to resolve the case at stake, then in itself, the condition of mandatory requirement need not be met. This is evidenced as we have had consultations and negotiations.
Okay, you're almost at 21 minutes. Can you quickly wrap up?
At this point in time, I'd like to yield the floor back to Mr. President. Thank you.
Thank you. Okay, let's hear from a respondent. You have a minute, I think, reserved.
Yes, Mr. President. Members of the tribunal, Claimant has pointed out and confirmed the point and the fact that both claims were on the basis of the destruction of certain plants. And the only difference pointed out by Claimant is that the prayers of relief are not the same. We submit that this is not enough to differentiate both claims, as that would essentially be using different theories of damage to address the same harm. Thank you.
Thank you. For the claimant, any rebuttal? You reserved 2 minutes, I believe.
We reserved 1 minute, and in sa rebuttal, in relation to the principle of res judicata, in relation to the subject matter, the principle, or rather the determination, is that there has to be reliance on the same prayers for relief in order for res judicata to apply with regards to cause of action. However, in the present dispute, there is no reliance on the same prayers for relief. Thank you.
Thank you. Asking my colleagues at this point whether you have anything else on the procedural stroke jurisdictional issues.
I just wanted him to restate the proposition, what he just said now. I don't think I got it. You said as long as, so just state it again.
Okay, sorry. In relation to res judicata, under the second limb of subject matter, there has to be reliance on the same prayers for relief in order for res judicata to apply. In the first case of Donald and Daisy, they relied on the prayers for relief of compensation for indirect loss of their shares. Whereas in the present case, we are relying on compensation for the physical damage that has been done to our investments at Odin and Triac.
Okay.
Thank you.
All right, got it. So you insist that as long as the claim for relief is different, the claims are different. Understood. Thank you.
So I believe you are muted, Mr. President.
Of course I am. Someone has to do it in every online event. I was saying, I believe we're now moving on to the merits phase of the hearing, and we will hear from Claimant's second counsel at this stage. If you could introduce yourself and begin.
Thank you, Mr. Arbitrator. Please confirm that you can hear me.
I can hear you loud and clear, and I assume everyone else can from the nodding of heads.
Okay. Mr. President, honorable members of the tribunal, if it may please you, good morning, good afternoon, good evening, depending on where you are. My name is Esther Nyabuto, as stated by my co-counsel, representing the claimant in this matter, Saturn Holdings Incorporation. In the next 20 minutes, I shall make submissions on the merits of this dispute. Many things are not as they seem, and the worst things never are. The Republic of Rekia on 10th March 2011 made it seem that they were committed to honor their obligations arising out of the Athabasca Rekia BIT when they signed the agreement. Unfortunately, we are before you today because of their failure to do so. With this backdrop in mind, I am going to make three substantive arguments. One, that the respondent violated its obligation to provide full protection and security to the claimant's investments. Two, that the clauses on compensation for war losses do not preclude the claimant from receiving compensation. And three, that the claimant is entitled to compensation for moral damages. On our first argument, we submit that the respondent violated its obligation to provide full protection and security to the claimant's investments. To prove this, we make the broad argument that the respondent failed to act in due diligence. Under this argument, we submit that one, the respondent violated its obligation of prevention. Two, the respondent violated its obligation of repression, and as a result, the respondent incurs international responsibility for failing to fulfill their international obligation. Before getting into the crux of our arguments, I would like this tribunal to take note of a few important points on full protection and security. Firstly, the full protection and security standard is established as at Article 5 of the Athabasca Rekia BAT. Paragraph 2 of the same article goes ahead to provide that full protection and security standard does not require treatment in addition to or beyond that which is required by customary international law minimum standard of treatment of aliens. The minimum standard of treatment of aliens requires the host state to exercise due diligence in an effort to fulfill its duty of full protection and security. We submit that the due diligence obligation applies vis-a-vis actions of third parties and that it requires the state to prevent harm from occurring, and when they fail to do so, the state should repress the harm. Now, going into the crux of our arguments, we submit that the due diligence obligation requires the host state to take all reasonable measures to ensure the protection of the claimant's investments, and they shall be responsible for their failure to exercise due diligence. This was the position by the Arbitral Tribunal in Sengis versus Libya, decision of 2018, as at paragraph 403. The duty of due diligence establishes both the duty of prevention and the duty of repression. I'm going to first establish that the respondent violated its obligation of prevention. The obligation of prevention requires the host state to exercise due diligence to prevent the harm from occurring. As such, the conduct that should be assessed in assessing the fulfillment of this obligation is the conduct before any harm occurs. This was the direction as established in Ampal American Israel Corporation versus Egypt, as at paragraph 245. The host state, in order to prevent harm, should at least be aware of the risk of harm, or at least the risk of harm should be foreseeable harm. In this case, we submit that the respondent did not prevent the harm despite being aware of the harm and despite the harm on the claimant's investments being foreseeable. We would like to draw this tribunal's attention to page 4, as at paragraph 12. If the tribunal is with me, the demonstrations in Rekia started soon after the legalization of the Cannabis Act. These demonstrations were recorded in various media reports, And in addition to such knowledge, the claimant's investment CEO wrote several requests for assistance to the respondent states since 2014, since the beginning of the war. The respondent state, through Mr. Rokari, in the emergency statement, acknowledges that they received such requests for assistance. However, we submit that the respondent state, despite being aware of the risk of harm, did not take reasonable measures to ensure the protection of the claimant's investments. In addition to this—
So, Counsel, in these facts that you're mentioning, you seem to put in the same category the seeming hostility towards the investment and the investors and their investment on one hand, and then on the other hand, the more serious facts involved in the armed conflict that ensued afterwards. And I wonder if these two categories of facts should be treated equally in terms of forcibility of conduct according to your standard. And more generally, I wonder whether the content of the FPS agreement is to be applied without taking into account the circumstances in which it applies, and whether the circumstances of hostility initially and then of an armed conflict do not warrant a differential application of the standard of treatment in terms of the level of protection that is to be expected to be provided by respondent.
Mr. Arbitrator, to answer your first question, we submit that the facts that you're relying on is as regards the FREA plant, as regards the full protection and security, is the conduct as regards the FREA plant. To answer your second question, indeed, the circumstances of the host state should be taken into consideration. However, the legal obligations entail—
But one point before you move on, you're telling me about conduct regarding one of the plans, but I was discussing rather your suggestion that the initial hostility towards the investor and investment before the armed conflict started is somehow to be treated on an equal footing with the actual armed conflict. So this is rather my concern. It's not about the differential treatment of the plans or the conduct as it pertains to the two plans as two different assets.
Indeed, Mr. Arbitrator, to answer your first question, the conduct of hostilities require the host state to exercise at least due diligence to ensure the protection of the claimant's investments. And upon the beginning of the armed conflict, the host state, when the armed conflict began, should have at least exercised due diligence as well to ensure the protection of the claimant's investments. Now, as regards your second question, the circumstances of the host state should indeed be taken into consideration. However, we submit that despite the circumstances in the host state, the treaty obligations within the Athabasca-Rekia BAT do not cease to operate. And because of that, the respondent state should at least exercise reasonable measures to ensure the protection of the investments. However, in this case, it is not a matter of the incapability of the host state to act. It is because the host state was unconcerned about the attacks on the FREA plant, as evidenced at page 63 at paragraph 41. Now, upon the occurrence of harm at the FREA plant, the host state should have taken reasonable measures to fulfill its duty of repression. As evidenced in paragraph 38 of the Statement of Uncontested Facts, the respondent state deployed only a few of its military towards the FREA plant after 48 hours. It is evident that the few military that they decided to deploy were not enough, and they were bogged down in low-intensity fighting. Had the respondent state sent enough military men, then the destruction of the FREA plant would not have resulted in complete obliteration. Having established that the respondent— Yes,
do you have any basis for assuming that respondents could have deployed additional troops at the time. There was, in fact, a civil war in process, wasn't there?
Mr. Arbitrator, to answer your question, we submit that the respondent state had they intended to ensure the protection of the claimant's investments, they would have sent at least a reasonable number of men to ensure that the FREA plant would not have resulted in complete obliteration. This is because the FREA plant had proved to be a catalyst of the war. So even before the harm was occasioned on the claimant's investments, the fact that the claimant had invested into the cannabis industry, which was in itself the catalyst of the war, the respondent should have taken positive measures to ensure that those investments within the cannabis industry should at least be protected.
So,
Council, what do you mean? Oh, pardon. Well, maybe I'll ask too many questions, then maybe you should ask first, and then I'll go ahead with my own question.
Okay, no, I was just going to, essentially, it's the same question. You are now addressing us as to how respondent allegedly breached the obligation to repress the attack on FREA. And the question is, you've said they should have sent enough troops. The facts indicates that they did send troops. In order to essentially persuade us that they breached their obligation, we need to understand your basis for saying that they could have sent additional troops. We have no evidence before us, at least you haven't pointed us to any of the means available to the respondent for the purpose of repressing the attack. The evidence as we see it suggests that some action was taken. To what extent are we entitled to second guess the states? We're not in charge of the state's armed forces. You need to do more to persuade us, and we're wondering whether there are additional facts that you could deploy in this regard.
And then, so I agree with the concern raised by Arbitrator Abdulkareem, and I'll add to that. I'm curious about your characterization of the investment as being a catalyst of the armed conflict. Are you asking this tribunal to draw any conclusions from that characterization, particularly in terms of any contribution of claimant to any breach of the obligations at issue, allegedly by respondent?
First of all, to answer your question, we are putting forward the fact that the cannabis industry was a catalyst of the war, to the extent to show that the risk on the claimant's investments was foreseeable, not to show that the claimant is involved. This is because the claimant would not have been involved and instructed that their own plants be destroyed. Now, to answer the first question,
so briefly, why do you mean by catalyst? Because to me, catalyst means that there is some degree of causal involvement in the breaches, so that we should regard it as a contribution among other possibilities. But you are denying this. You're saying it is only a catalyst for one purpose, for civility, but not for another purpose, for which it can logically be assumed to play a role. So could you clarify what you mean by catalyst specifically?
As catalyst, we mean that this was a controversial industry in which it led to a lot of unrest in the respondent state. Additionally, this is to show that it was a catalyst because it was a target of the attacks, not that it resulted not that it took part in resulting into the war. To answer the first question, we submit that the respondent state sent its military forces and its troops according to Respondent's Exhibit R1 to financial districts. The respondent claims that the financial districts is where their government and civil service were based. However, we do submit that according to Procedural Order number 3, other investors were within those financial districts. So the fact of differential treatment can very well guide this tribunal to show that the respondent state had the capacity to send more men towards the FREA plant.
I wonder if that fact doesn't rather cut against you, because as you pointed us to PO3, that paragraph actually indicates that even in the places where the respondent deployed troops, investors lost properties. Therefore, the respondent actually did not have enough troops to secure properties either in the financial district and arguably at Freya, unless you suggest that all of the troops of the respondent should have been deployed to Freya. Is that the submission?
No, Mr. President, no, Mr. Arbitrator, that is not the position. However, our position is that we do acknowledge that at least some damage would have occurred towards the claimant's investments. However, it would not be as to the degree that it occurred had the respondent state at least sent some additional men. Having established that they violated their obligation to provide full protection and security, we submit that under Article 10 of the ILC Articles on Responsibility of States, that the respondent incurs international responsibility for their failure to provide an international standard of protection. I would like to move to our second limb of argument, where we submit that the clauses on compensation for war losses do not preclude the claimant from receiving compensation. Article 6 of the Athabasca-Rekia BAT establishes both the non-discriminatory clause and the extended war clause. We do not have any contention as regards the non-discriminatory war clause, but we submit that under the extended war clause, the claimant is owed compensation. This is because the destruction done at the Odin plant was conducted by the governmental forces through the Rekian soldiers, as well as the destruction was not caused in combat action or was not required by the necessity of the situation. Combat action involves armed conflict between the state and governmental actions, as was in this case. This was a non-international armed conflict, and as established at paragraph 33 of the Statement of Uncontested Facts. Now, in this case, the respondent state took the direct action against the claimant's investments by placing explosives, which led to the complete obliteration of the Odin plant. We submit that it did not occur within combat action because at the point of placing these explosives, the move by the militia groups was slow and more cautious than before. As a result, the respondent cannot rely on the necessity of the situation because this in itself was not caused during combat action. Now to move on.
Let me ask a question on that. What standard are we meant to apply when we're evaluating a claim about whether action by a military is necessary or not? I mean, you're asking about something that's sort of outside of our general expertise, and you're trying to persuade us to reach a factual finding about the necessity. What should we be guided by in weighing that question?
Yes, Mr. President. Indeed, at paragraph 2 of the procedural order number 3, both parties to the Athabasca-Rekia BAT are parties to the law of armed conflict, including the Geneva Conventions, and generally international humanitarian law. For military necessity, as established in international humanitarian law, military necessity the principle of military necessity will not be allowed when the destruction is unnecessary and when such destruction is unnecessary and excessive and thus prohibited. This is a violation of Rule 7 of the customary international humanitarian law, where attack against civilian objects is prohibited. We submit that this is exactly what the respondent.
So briefly, a similar concern to that of the presiding arbitrator. So are you asking the tribunal to apply the customary international law on armed conflicts in order to decide whether the respondent's conduct was or was not necessary? Do we have jurisdiction to take into account this kind of law, and if so, on what basis?
The customary international law on armed conflict, this tribunal has jurisdiction because both parties in this dispute are parties to the laws on customary international law, as evidenced in paragraph 2 of procedural order number 3. Onto our last limb of argument, we submit that the claimant is entitled to compensation for moral damages. I see that my time is almost up. I would like to request an additional minute to summarize?
You may have 1 more minute.
Thank you, Mr. President. We submit that the claimant suffered moral harm as a result of the respondent's actions, and that the proof of exceptional circumstances is not a requirement. Firstly, the award of moral damages is established in Article 31 of the ILC Articles on Responsibility of States, where reparation should be owed where the damage is either moral or material. In this case, we submit that this tribunal has jurisdiction to award moral damages as guided by Cementonius Noahuta versus the Republic of Turkey, where it was established that nothing in the ICSID Convention or arbitration rules or additional facility rules preclude tribunals from awarding moral damages. Additionally, we submit that this is not punitive damages, as the respondent might likely allege, because punitive damages is excluded as at Article 25 of the Athabasca-Rekia BAT. In this case, we submit that moral damages are compensatory in nature and are in no way supposed to punish the respondent state. The claimant suffered reputational harm as well as emotional distress to its employees as a result of the respondent's inaction to fulfill its duty of full protection and security, as well as their allegations as against their claimant, their allegations in supporting the military. Additionally, we submit that the proof of exceptional circumstances is not a requirement, and having established that the claimant suffered moral harm as a result of the respondent's actions, then that in itself is enough to persuade this tribunal to award moral damages, as was established in the case of Arif versus Moldova by the ICSID tribunal in the award of 2013. Seeing that my time is up, I would like this tribunal to find that the claimant is owed compensation for moral damages because of the harm suffered as a result of the respondent's actions, and that this tribunal should find that the respondent failed to fulfill its duty to provide full protection and security. 2, that the clauses on compensation for war losses do not preclude the claimant from receiving compensation. And lastly, that this tribunal should award a compensation of 45 million USD for damages, as well as 10 million USD for moral damages. With that, we rest our case. Thank you.
Thank you. Any follow-up questions at this point from my colleagues?
None for now.
Then let's hear from the respondent's second counsel on the merits.
Good day, members of the tribunal. As introduced by my co-counsel, I am Alonge Gloria, and in the next 19 minutes, I will be addressing issues on merits on behalf of respondent, the Republic of Rekia. Members of the tribunal, Rekia, a developing country, welcomed with open arms the investment of Sultan Odins in their country. However, it is unfortunate that during this period, Rekia was faced with an unprecedented civil war, which threatened the very existence and survival of the state. As a state charged with the primary duty to protect lives, Rekia had to take necessary measures to put an end to the civil war. Nevertheless, even under these trying circumstances, respondents did provide security to claimant's investment to the best of its ability. In light of this, we will address the issues raised by claimant counsel in the same order for the convenience of this tribunal. As such, we request this tribunal finds, first, that respondent is not in breach of the full protection and security standard stated in Article 5 of the BIT. Second, that claimant is not entitled to compensation for war losses under Article 6 of the BIT. And lastly, that claimant is also not entitled to moral damages. Members of the tribunal, moving to the first issue, we will make 2 submissions. First, that the destruction of claimant's Odin building is justified by the defense of necessity. And second, that respondent acted in fulfillment of the due diligence obligation. Members of the tribunal, Article 5 of the BIT provides for the minimum standard of treatment. According to the case of AAPL against Sri Lanka, this is one of due diligence, that the state will act reasonably under the circumstances to protect the investor's investment. It is our submission that respondent has done just this. Claimant counsel cited the case of Senjis against Libya, holding that the state of Rekia should be held responsible because they failed to provide protection to prevent the attacks in the first place. However, in that case, in the case of sanctions against Libya, the state was held responsible because it had in fact provided static protection to other investors. Members of the tribunal, the Respondents' Council also contended on foreseeability that the state should have been able to provide security forces to prevent the attacks in the first instance. However, members of the tribunal, Claimant Council fails to mention that this obligation is one of means and not of result, which means that as long as the state has acted reasonably under the circumstances, then it is not in breach of the full protection and security standard. Members of the tribunal.
Briefly, Council, so was this distinction between obligations of means and result not considered by the ILC when it codified the articles on the law of state responsibility, but ultimately dropped and not included? So why should we take it into account? Just briefly, if you could elaborate on this, on the relevance of this distinction.
Members of the tribunal, this distinction is relevant because it goes on to state what was reasonable conduct of the state in that instance. It is our submission that based on the case of Pantechnicki against Albania, the same responsibility cannot be expected from states that have different capacity. Simply put, developed states with more resources in their capacity should not be held to the same liability as developing nations with limited resources. And this was the rationale in the case of Pantechnicki against Albania. Specifically in paragraph 77 of the award, it states that it seems difficult to maintain that a government incurs international responsibility for failure to plan for an unprecedented trouble of unprecedented magnitude in unprecedented places. Members of the tribunal, the civil war in Rekia was unprecedented, yet the respondent states did act in fulfillment of its due diligence obligation, given the circumstances.
So Councillor, so what do you make of Claimant's submission that it was foreseeable because prior to the armed conflict, there had been an atmosphere of hostility towards the investors and investment? Doesn't that make it somehow foreseeable and therefore not as unprecedented as the Pantechnicki, as the situation in the Pantechnicki case that you mentioned?
Mr. Arbitrator, it is our submission that even before the attacks on Claimant's plant, respondents did provide security. During the protests in Rekia, respondent included the use of its military forces to prevent the protests from escalating in the first instance. Members of the tribunal subsequently, upon calls for help by the CEO of Sutan Investments, respondents did provide security forces to defend Claimant's Odin plant within 48 hours of the attack. As such, respondent did act reasonably even before the attacks, during the attacks, and even after the attacks. It is also our submission, members of the tribunal, that Respondent Council made mention of the case of Ampal American against Egypt. However, in that particular case, the BIT had no provision on the minimum standard of treatment. As such, the tribunal applied a stricter approach in holding the state responsible. It is our submission that based on the minimum standard of treatment, the state's responsibility should be proportionate to its resources. As such, given that Rekia was faced with a civil war, yet the state was able to provide security, given the circumstances, Rekia has not acted in violation of the due diligence obligation. Similarly, it is our contention that
so briefly, before you move on, so what you're telling us is that this element of level of development in terms of the extent of the scope of the respondent's obligation is to be taken into account not as a matter of the FPS standard of treatment as such, but rather as a matter of the minimum standard of treatment. And if that's the case, that standard being here taken into account as a matter of customary international law, what is the state practice and opinion juris allowing us to reach that conclusion that you seem to be making.
Mr. Arbitrator, it is a submission in this instance that the minimum standard of treatment is in line with the due diligence obligation that the state will act reasonably. Now, what would amount to reasonable conduct would in fact depend on the capacity of the state. As such, based on the authority of Pantechnici against Albania, it is our submission that the state has acted reasonably. Similarly, it is our submission that the destruction of Claimant's Odin plant is justified by the defense of necessity. Members of the tribunal, Claimant Counsel fails to point this tribunal to Article 28 of the BIT, which provides a non-precluded measure, basically stating that the state would be allowed to take measures that are necessary for the protection of an essential interest against imminent peril. It is our submission that in this instance, that was exactly what the respondent state did. And this was because the claimant's plant was by means of purpose and use was such that it became a military objective. As such, to prevent the continuation of the war, given that the armed militia had in fact made use of gotten food from other buildings in the outskirts of Odin to continue the war. The respondent state had to make a necessary call by destroying all buildings capable of agricultural production to prevent the undue continuation of the war. If there are no further questions by the members of the tribunal, this concludes our submissions on the first issue, and we will now proceed to address the second issue, that claimant is not entitled to compensation for war losses. Members of the tribunal,
just before you move on, assuming that you were persuaded that there was military necessity for the destruction, the BIT Article 6.1 still envisages that the state will pay compensation, albeit on a non-discriminatory basis, to investors who lose their investments as a result of wars. Therefore, the defense of military necessity doesn't necessarily absolve you completely of your potential liability to claimants. Do you want to address us as to what measures the respondent state has taken at all in relation to compensation for investors who have lost their investments as a result of its action or as a result of the civil war?
Mr. Arbitrator, I understand your concern. However, Article 6, subparagraph 1 of the BIT does not impose a strict obligation to compensate. As was held in the case of Sanchez against Libya, such clauses that provide that the state should compensate in line with the most favored nation treatment simply do not create a strict obligation, but rather describe how compensation should be taken if the host state decides to compensate. An obligation would only arise if the claimant can prove that respondent has in fact compensated other investors in similar situations as claimants, which is not the case in this instance. If I may direct members of the tribunal.
So Counsel, to understand your submission in this regard, what you're telling the tribunal is that insofar as paragraph 1 of Article 6 provides for either national treatment or MFN treatment, the condition for the application of either treatment as regards compensation is subject to the prior extension of any treatment in that regard. Therefore, because there has been no treatment accorded to anybody, Article 6, paragraph 1 does not apply at all in the present circumstances.
Mr. Arbitrator, this was also considered in the case of CMS, and it was held that such provisions are merely non-discriminatory and simply provide for a flawed treatment for all investors. They do not strictly impose an obligation, but only state how compensation should be gone about, should be taken in the event that the state decides to compensate. Mr. Arbitrator, the clause that creates an obligation to compensate is in fact Article 6, subparagraph 2 of the BIT. However, it is our contention that claimant is still not entitled to compensation for war losses under Article 6, subparagraph 2 of the BIT. And this is because Article 6, subparagraph 2 provides that there will only be compensation where the actions of the state did not occur in combat action and cannot be justified by the defense of military necessity. It is our submission that respondents' actions did occur in combat action and can be justified by the defense of military necessity. If I may direct members of the tribunal to page 63 of the record, page 64 of the record, specifically members of the tribunal, paragraph 42. From the last sentence, it states that the soldiers took control of Odin and were billeting in the work camp accommodations. Over the course of the next few months, Odin was slowly surrounded by armed militia groups, and soon Rekian soldiers found themselves surrounded with dwindling supplies. Members of the tribunal, this in fact proves that Odin was in combat action during the time of the destruction of the plant. Also, based on Article 52 of subparagraph 2 of the Additional Protocol 1 to the Geneva Convention, it defines what military objects are. Claimant counsel has argued that their building was a civilian object, as such, the destruction was not necessary. However, it is our submission that in this instance, it in fact amounted to a military object. And this is because that particular provision provides that where civilian objects by way of their use and purpose become such that the destruction would in fact confer a military advantage on the respondent state, then they can be legitimately attacked. And this was also upheld in the report of the International Committee of the Red Cross in 2006. As such, by way of the purpose and use of the plant by the armed militia group, the building of Claimant in fact became a military object and was legitimately destroyed. As such, the defense of military necessity applies in this instance. Also, members of the tribunal, moving on to our final submission, it is our contention that Claimant is not entitled to compensation for moral damages. And this is because moral damages was not provided for in the BIT. As was held in the case of OIEGB against Venezuela, specifically paragraph 906, it was stated that where the BIT does not make any reference to the possibility that the investor may claim for moral damages, then moral damages is not applicable. Members of the tribunal, the intent of the parties in the BIT show that they did not in fact contract to allow for the award of moral damages. Alternatively, members of the tribunal, it is our submission that even if moral damage.
Let me stop you because you're going to move on to your even if. You cited us to one case. I'm not familiar with that case, but it seems to me that there's a fundamental issue if there is lack of complete or full reparations in a case where there are certain types of damages. For example, reputational damages is, I think, part of what is being claimed here. Is it right that you need to specify moral damages in a treaty? What's the principle that underlies the case that you cited us to? You've given us a cite without an explanation, and I'd like to understand the reasoning.
Mr. President, it is our contention.
And I have an additional concern, related one, which is you seem to be telling us that the award of moral damages is a matter of whether it is provided or not in the applicable BIT. But I wonder more generally whether, and this perhaps follows up on Mr. President's question, whether as a matter of the law of state responsibility, even if the BIT does not expressly provide for awarding moral damages, whether we could, or we will be, or we will have to award moral damages. Because in principle, unless you hold the contrary, the law of state responsibility does not limit the kinds of damages that for which compensation can be granted, at least in terms of the distinction that is at play here.
Thank you very much, Mr. Arbitrator. Answering the first question, it is our submission that where the provisions of the BIT are not ambiguous, they should in fact be given a strict interpretation. And since moral damages was not provided in the BIT, it is not applicable in this instance. Also answering your question, Mr. Arbitrator, it is our submission that the BIT in fact makes provisions for compensation. However, moral damages are excluded under the compensation clause. And this gives rise to the intent of the parties in the first instance.
So, and you're more familiar with the express terms of the treaty than I am, but when you say that moral damages are excluded, is that express or is that read? Are you reading that into an absence of a reference? Can you, in other words, take me to whatever shows that they're excluded?
Mr. Arbitrator, though the parties did not expressly exclude it, it was stated that punitive damages would not be awarded. And
okay.
In this instance,
so now you're equating moral damages with punitive damages, and I'm wondering where that equation comes from because it's not an equivalence that I'm familiar with.
Mr. Arbitrator, it is our submission that in this instance, considering the requirements for moral damages, what claimant seeks is in fact punitive. And this is because claimant seeks to get compensation for the actions of respondent. However, the actions must in fact be grave in cause and effect for moral damages to apply. The only actions of respondent that can be pointed to in this regard is the investigation on the links between claimant and the armed militia. And these investigations, as was stated in the facts, are to be conducted in accordance with due process of the law. As such, it is our submission that awarding moral damages for investigations in this instance would be punitive because all the state has done would be to pursue the legitimate interest of.
All right. I think we're mixing up whether you think the damages are proven and inapplicable here with the categorization of them as punitive. But I think I understand your argument.
Thank you, Mr.
You've got about a minute, a little bit more than a minute left, so you might want to start to think about wrapping up.
Thank you, Mr. Arbitrator. Seeing that my time is almost up, I'd like to request an additional 1 minute to wrap up my arguments.
Go ahead. Thank
you, Mr. Arbitrator. It is therefore our submission in this instance that respondent's conduct was not grave in cause and effect, and also that respondent's conduct were not malicious because investigations do not amount to an admission of guilt in the first instance. And in the first place, the investigations would even further help in clearing claimant's names, in clearing claimant's reputation, if indeed they were not responsible for funding the armed militia. As such, it is our contention that claimant is not entitled to moral damages. If there are no further questions by the tribunal, this concludes our submissions. Thank you.
Well, perhaps I was left with the question of the conflation of the kinds of damages, punitive, moral, etc. But then there is the question of, if we were to consider that the damages in question are not punitive, is there any other reason that you would argue for in the alternative for this tribunal not to award moral damages? If we are to reach the conclusion that the damages in this case are not punitive.
Yes, Mr. Arbitrator. Even if moral damages were to apply in this case, it is our submission that claimant's actions respondent's actions do not meet the gravity requirement and also the malicious or fault-based conduct requirement as laid down in the case of Lemur against Ukraine, because the state has only conducted investigations and such acts cannot be deemed as grave. Thank you.
Thank you very much. Unless we have any other questions to the tribunal, we will go to our rebuttals. And I think we don't have questions at this point from the tribunal, so if we can have the claimant's rebuttal.
Mr. President, members of the tribunal, two things. The respondent has made heavy reliance on additional protocol 1, which involves the conduct of the parties within an international armed conflict. Submit that in this case, what was experienced in Rekia was a non-international armed conflict, and therefore their reliance to justify the necessity as they claim cannot be justified for the reliance on war relating to international armed conflict. Secondly, the respondents' assertions as regards moral damages not being contained in the BIT, we submit that several previous tribunals have considered the award of moral damages despite them not being expressly mentioned in BITs. Case in point being the Desert Line Projects LLC versus Yemen, where the claimant was awarded moral damages for reputational harm and for harm against its employees, as is the case in this dispute. We therefore submit that the respondent's assertions that it is not expressly mentioned in the BIT should not be used by this tribunal. Thank you.
Thank you. And respondent, any rebuttal?
Yes, Mr. President. Claimant counsel seeks to rely on the case of Desert Line against Yemen to justify the moral damages compensation. However, in that case, there was actual physical arrest of the employees in that case. In this instance, the respondent state has not acted in hostility in terms of arresting or otherwise being physical with the employees of Sutton Holdings. Similarly, as we have stated earlier, the actions of the respondent state, in fact, do not conform with the requirements of gravity and malicious or fault-based conduct. As such, this tribunal should not award moral damages. Thank you.
Thank you very much. Any final questions from the co-arbitrators?
Just a question, and actually for claimants, the points made in relation to we should be, the standards discussed by respondents should apply to an international armed conflict only. What's the support for that? Were you referring to Article 6 of the BIT or something else?
I was referring to the claimant's reliance on Additional Protocol 1, which relates to international armed conflict.
Understood.
Yep.
With that, I will stop the live stream.
Well, I was about to say, I think we are now done with the arguments. And so we are able to come out of role play. I think the next steps are first for us to congratulate you all on a fantastic job. And I think we then will go into a separate breakout room to discuss the result. But you should all be very proud of yourselves. It was very, very strong and well done. We maybe have some time to chat later. But many congratulations for such a strong performance from both teams.